Well, good morning, everybody, and welcome to the Fredericton Chamber of Commerce webinar today. We're so glad you could join us, and we want to say a special thank you to our two presenters today, Lindsay Bowman, who's with Connor Stillwell, and Mike Melvin, who's with McInnes Cooper. We've been working hard to present a number of these types of webinars and workshops to our members to help them to understand different aspects of what they can be doing during this pandemic. And we've had HR workshops. We have one coming up on cybersecurity, and we have a number of different ones. But today we're going to talk about legal issues and highlighting, the outline said, highlighting key legal pitfalls that business owners need to avoid while navigating during these critical and challenging times. So without any further ado, I'm going to turn it over to Lindsay and Mike. And I know Tanya's going to mute your mics, but there is a chat feature where you can put questions, which we can address towards the end. And if there is time, we will work on some of those questions. And I know that's the intent. So without further ado, I'll turn it over to Mike and Lindsay. And thank you so much again. We really appreciate it.
Thank you very much. So we spoke before the presentation. We've decided that we're really doing kind of two presentations in order. So I'm going to go first, and then Lindsay, I'm going to address sort of some business law issues, really contract issues, and then Lindsay is going to address some employment law considerations in the second half of the presentation. So without further ado, I will attempt to share my screen. And this did not go entirely smoothly the first time, so bear with me for a second, please. So hopefully everyone can see my screen now. Excellent. Okay, so you know, as has just been said, you know, my name is Mike Melvin. I'm a partner with McInnes Cooper here in Fredericton, and I'm a corporate commercial lawyer. So really, you know, I deal with business, contract matters, people buying and selling businesses, intellectual property, things like that. So, you know, really my presentation is focused more on how COVID-19 impacts your contractual relationships. And in particular, really what I'm focusing on is, you know, ways and the extent to which, you know, you may be able to, you know, get out from under some of your contractual obligations if necessary. And to that end, I'm going to talk a little bit about three particular legal doctrines here. One, which is called force majeure, which is a contractual rule that may be available in some cases, a doctrine of frustration, and a doctrine of waiver. And at the end, I'm going to touch a little bit on commercial leases. I'm not going to do a deep dive on that, but you know, I think for most small businesses, basically between their leasing obligations and their employee obligations, those are probably their, you know, their largest costs. So I thought that was significant to just highlight at the end. So obviously COVID-19 has created pretty widespread business disruptions. And the question frequently comes up, you know, to what extent does this relieve people of their obligations contractually? And, you know, the corollary to that is, you know, to what extent may it relieve people who owe you obligations from performing? So particularly in the case of suppliers and things like that. So the three key legal doctrines we're going to discuss, as I said, force majeure, frustration of contract, and waiver. So the first two really deal with, you know, how can you be relieved, or under what circumstances are you relieved of your contractual obligations? And the last one really deals more with, you know, how people can essentially collaborate and sort of waive some obligations to help one another out. And I think really in many cases, that's going to be the most productive way forward during this time. So I'll talk a little bit about force majeure. So, you know, there's been a lot of talk about this ever since COVID-19, you know, came on the radar. And some people may already have attended, you know, some webinars or other sessions that deal with this. So what is a force majeure clause? And it is a clause. So force majeure really only exists in contract law. The only way you can avail yourself of this assistance is if it's written into your contract. So essentially what a force majeure clause does is it temporarily suspends your obligation to perform a contractual obligation. So since this is an entirely contractual creature, for lack of a better word, the first question you have to ask yourself is, does your agreement have a force majeure clause? most commercial agreements, in my experience, will have some sort of force majeure clause. Not all, but it's fairly standard. But you need to check that. Assuming that you have one, the next question after that is, how is your clause worded? Because again, being a matter of contract, the wording of the clause really defines what types of events will be considered to give rise to force majeure. And I guess I'll back off or back up for a second here and just explain a little bit. When we talk about force majeure, and this is covered a little bit in the quote here, what we're talking about is what used to be referred to as acts of God. Essentially, events, supervening events that happen outside of the control of the parties to a contract that prevent them from performing the contract. But in these clauses, they will typically lay out exactly what types of events will apply. And so if a certain type of event is not covered, then you may not be able to use the clause in the particular case. So on that point, for example, I would say it's a bit hit and miss whether or not your force majeure clause, assuming you have one, is going to cover necessarily pandemics or outbreaks of communicable disease. I think in the wake of SARS and H1N1 and some of the other pandemic or epidemic type events that have happened in recent years, there has been more effort, I think, put into including this type of language. But whether or not it's actually in your contract, I think is frankly, it's probably a 50-50 shot. The other thing to consider, besides identifying what events will qualify, as a force majeure event that may relieve you of your obligations, you also have to consider if any obligations are excluded from force majeure protection. So again, it's a matter of contract. It's what the parties write and what they agree, in the written agreement. And sometimes some of these clauses will exclude the protection from certain types of obligations. So frequently in leases, for example, and in some other types of relational contracts, the force majeure clause will not apply to payment obligations. So for example, even though there is some event, event beyond the control of the parties, which creates difficulty or impossibility, the clause may explicitly say that this does not apply to payment obligations. So for example, you may still, even though you have a clause that you could rely on for some purposes, you may not be able to rely on it to relieve you of your obligation to make payments. So courts tend to interpret these clauses strictly, and this is a bit of a theme that we're going to see both in this discussion of force majeure and also in the discussion of frustration, right? Courts don't like to, bring contracts to an end prematurely or in a way that's not contemplated in the contract. So in interpreting these force majeure clauses, the courts tend to take a very narrow interpretation, and there are a few principles that tend to come up in the cases over and over again. So, besides looking at the specific language of the clause and what qualifies as a force majeure event and whether or not there are any exclusions and so on, the court is going to interpret it through this prism of looking at, was the event actually a supervening event? And what that means is really an event that sort of came up unexpectedly. Is it actually beyond the control of either party? And this is a very important consideration because one of the rules that comes up in the case is that you can't rely on your own act, essentially. So if you voluntarily take some step that undermines your ability to perform, you're not going to be able to claim force majeure. And that's common sense, really, but it's an important consideration. Does the event actually render performance impossible? And this is really, I think, where the challenge in using these clauses in the context of COVID-19 is perhaps the greatest. I'll talk a little bit in a minute about how this clause or this type of clause may interact with the mandatory order issued by the provincial government. But I think impossibility is probably one of the stumbling blocks in trying to avail yourself of these clauses. The other principle that the courts tend to apply is that the event must not have been reasonably foreseeable. So I think this is really in connection with COVID-19 going to be a bit of a timing issue. If you agree to perform an obligation back in October, November, before COVID-19 was really on people's radar, probably that's not going to be a stumbling block for you in trying to use one of these clauses. But if you signed an agreement a week before the declaration of emergency happened, when everyone already knew that, things were about to jump off, arguably, I think quite arguably, it was foreseeable that something could happen. So taking these sort of principles, and trying to apply them to a factual situation. I think in the context of COVID-19, you really need something specific. If you're going to try and use these clauses, you need something very specific to point to as your supervening event. It's certainly not going to be enough to simply say, oh, COVID-19, right? You have to point to something more specific. So, for example, if the COVID-19 pandemic, and in particular some of the government actions that have been taken, you're restricting certain activities, if that has created, for example, an insurmountable supply chain issue for you, then really you're going to be citing the supply chain issue. And you may, I think, probably some of the most fertile ground, I guess, for potentially claiming this protection is going to be looking at the government order, the mandatory order that was issued by the provincial government and which has been updated a couple of times. Most force majeure clauses, in my experience, do contain some language that make orders or acts of government or public authorities an act of force majeure. So I think in most cases where you do have some possibility of using these clauses, you're going to be pointing to the mandatory order from the provincial government. Now, again, getting back to the impossibility question, I said that the fact that this type of event has to render performance impossible creates a bit of a hurdle. And if you look at the mandatory order that was issued by the provincial government on March 19th, and it's been updated a couple of times, I think most recently on the 2nd of April, it's very carefully worded and very carefully crafted to allow the maximum amount of business activity, without, contravening these health concerns about, proximity and so on. So, there are very few businesses, I would say, or certainly, the minimum number possible that are actually ordered to cease operating, right? Typically, this tends to be curtailments on what you can do. So, for example, restaurants are allowed to do takeout and delivery; they just can't do sit-down dining. Similarly, there's certain types of retail stores that are allowed to operate. Certain types of regulated health professions are limited in delivering services, to services that they consider to be essential for the well-being of clients, but they are still allowed to do that. So I think on the impossibility front, the wording of the order makes it a little bit challenging to claim force majeure. I think where you possibly could would, for example, be if you operate a licensed banquet facility, and say you had entered into an agreement to host a wedding reception on March 25th. In that case, I mean, clearly you're not permitted to admit patrons. That's an act of governmental authority. So I think you'd be in a pretty good position to claim force majeure in that case. But I think there are a lot of lesser cases where it's going to be more difficult. And an important point to keep in mind, even though it's not written on the screen here, is that one of the rules is also that, just because a supervening event makes performance more difficult or more expensive does not equate with impossibility, right? If it's still possible for you to perform, even though it's more costly or more burdensome, in most cases, you're really not going to be able to rely on force majeure, unfortunately. I'll move on a little bit and talk about frustration. So force majeure is a matter of contract, right? It has to be written in the contract. If you have the clause, and if the clause is worded properly, it may be of assistance to temporarily suspend your obligations to perform certain obligations under contract. Frustration, in a sense, is more useful in that it does not have to be in a contract. It's a matter of common law. It's a common law doctrine. However, I would say the bar for claiming frustration is very high. So essentially, frustration is a circumstance. It's essentially common law force majeure, broadly speaking, where the court will find that there's been a supervening event that renders the performance of the contract impossible, and therefore the contract is at an end, or in some cases it may just temporarily be suspended. There is legislation in New Brunswick, the Frustrated Contracts Act. It doesn't define frustration, but it essentially codifies certain entitlements that people have when a contract becomes frustrated. So, what money can they expect to be reimbursed? Can they recover costs, et cetera, et cetera. So it is relevant, but it doesn't really define when frustration has happened. So on the next page, I have some of the principles, and these are certainly not an exhaustive list of principles related to frustration of contract, but there's some of the relevant ones that I think you have to keep in mind. So whether or not a contract has become frustrated is going to be a fact-specific determination. And what that means really is just that the court is just going to weigh the facts of each case to decide whether or not, has there really been a supervening event, an unexpected event, and has it really rendered, the contract impossible to perform? And I would say, having reviewed the New Brunswick case law on this, courts are very reticent to find that a contract has been frustrated. There are a number of Court of Appeal decisions. A number of them relate to actually attempts to transfer fishing licenses and things like that. But really, there was only one case I could find where the Court of Appeal had said that a contract was frustrated and was at an end. And it was a case where an agreement was entered into between two fishermen to transfer a crab license. However, once the deal was struck, there was a complaint to the Department of Fisheries and Oceans, and they refused to approve the transfer. And the court said, well, there's not much we can do about that. Clearly, the contract is frustrated. But there are a number of other related cases, similar cases, where the court has found there's been no frustration, either because the problems were the result of one of the parties, not, making an application on time, for example, or, some other sort of self-induced difficulty. So the bar is pretty high. And this, I guess, links into my second point, which is that, the supervening event, when you're trying to claim frustration of contract, it can't be a voluntary act, right? It has to be something from outside. Again, an increased financial burden or an increased difficulty in performing a contract does not create frustration. So really, I mean, the key, I would say, with questions of frustration of contract really comes down to whether it's possible or impossible. And, as I said earlier, the courts are very reticent to find that a contract is at an end. And actually, there's an older case here, actually from 1950, a lumber-related case, where a party, a lumber mill, tried to claim that their obligation to deliver a bunch of timber to a buyer was frustrated because there'd been a forest fire, there'd been manpower problems, there'd been a strike in the rail line. They weren't able to avail themselves of cars to ship the lumber for a long time. But the court basically said, look, these are all temporary things. I mean, yes, your obligations were suspended while those things were going on, but this doesn't, essentially bring the contract to an end. And they found that, okay, once all these problems were over, then you still have the obligation, to perform your contractual obligations and deliver the timber. So definitely a very high bar, which leads me to my discussion of the doctrine of waiver. Force majeure and frustration certainly can be powerful tools if you have the right facts. Particularly in the case of force majeure, if you have the right contract, the right contract terms. In the case of the doctrine of frustration, if you have the right facts, certainly can be very helpful. But the bar is pretty high, and the courts tend to take a very narrow interpretation of these things. I think, practically speaking, for most of the clients that I've dealt with in the context of COVID-19, they're more likely to get relief from some of their contractual obligations through agreement, right? So, I'm sure we've all spoke to people or probably done this ourselves. As tenants under commercial leases, many tenants have approached their landlords, sought, some form of rent relief or some, form of deferral. Under other types of agreements, their payment deferrals have been sought, et cetera. And I think really in many cases, that's going to be the best approach to trying to manage your resources and your obligations during the pandemic. There are a couple of things to bear in mind, though. So waiver is a legal doctrine, and essentially what it means is that you're voluntarily giving up a right. There is obviously case law on this. In order to validly waive a right, you have to have full knowledge of your right, and you have to unequivocally signal, that you are waiving the right. It can be done by conduct. It doesn't have to be in writing, but it has to be pretty clear what your intention is. So I would say, taking this into consideration and also taking the prevalence of non-waiver clauses in contracts into consideration as well. And just for a second, I'll explain briefly what non-waiver clauses are. These are clauses that occur in many contracts, which essentially say that we are, unless we put it in writing, we're not waiving any rights under the agreement. So many agreements have this. So I would say taking the rules around waiver, the common law rules, and also taking the prevalence of non-waiver clauses into account. If you do negotiate some kind of deferrals or relief of some kind from people to whom you owe payments or other forms of contractual performance, really you should always try to get it in writing. That makes it very clear what the party's intention is. There's no question that it was, essentially, that what you're claiming was waived was actually intended to be waived. But more to the point, it also, I think, gives focus to the parties to work out, okay, so what actually happens after this period of waiver, right? So if I'm going to waive your obligation to pay rent, for example, for April, when do you pay it? Do you pay 2 months right away in May? Are we going to break it up and you pay it out over a certain period of time? So whatever you have kind of looser handshake type deals, I would say that one of the risks is that the various scenarios are not really thought out and not really contemplated ahead of time. So certainly, I think waiver is probably one of the best avenues to try and obtain relief from your contractual obligations. But I would recommend everyone to have this worked out and put in writing. So last slide. I hope I'm not taking up too much time. I can't actually see my clock here. Commercial leases. So I'm just going to touch on this briefly. One of the main concerns that really people were kind of freaking out about, first when the declarations of emergency came out and the related sort of government actions and restrictions was, how am I going to pay my rent? Because the truth of the matter is, for many small business people, particularly in the retail restaurant space, you're probably only a month away from not being able to meet your obligations at any given time, frankly. So the prospect of being shut down or having business significantly curtailed for a number of weeks was very alarming for many people. In response to that, the provincial government here and some other jurisdictions has come out with some protection. And I want to just talk about how that affects the rights of tenants and landlords. So typically, if there's a breach of lease, there are three main remedies that the landlord would have. So the landlord can seize and sell the goods. This is called distraint. In an attempt to recoup rent arrears, you can start an action, sue for the arrears, or you can terminate the lease. And you can also, of course, seek injunctions. But the three main remedies are the ones listed here on the screen. So how does this affect the obligations of the parties in light of the mandatory order that was issued by the provincial government? Because the revised and restated order, as revised, I think, on the 25th of March, included some protections for commercial tenants, right? The first version protected residential tenants and said that no one could be evicted, until, basically the current situation had passed. And then in the second restatement, or the first restatement of it, they included protection for commercial tenants. And what this says is that no landlord shall, in relation to any commercial tenancy, and I'm paraphrasing here, give a tenant any sort of notice to quit, re-enter, or repossess the demised premises, that would mean the lease premises, or exercise any right of distress. So that would be the right I mentioned a few minutes ago, the right to seize and sell the tenant's property to recoup the rent, until May 31st for non-payment of rent that came due after March 19th. So what exactly can landlords do, and what exactly is the extent of the protection the tenants have? So I would point out, first of all, that from the landlord's perspective, you're really only restricted with respect to rent arrears that occurred after March 19th. So if you had a tenant where you were already in a position to take action before March 19th, then I don't think the order really prevents you from doing that. I would also point out that the restrictions here really only relate to arrears of rent, right? So if there are other reasons, other defaults under the lease that would entitle you to take action, on my reading, this does not restrict you from doing so. So essentially, rent arrears that happen after March 19th, your hands are pretty well tied by this order. But I would say for rent arrears that were already in existence, or for other defaults under the lease, really, the situation is as before, notwithstanding that the courts are, semi-shut down and the practicalities of enforcement will be more difficult. So, what can a landlord do in these cases? Even if you are in a situation where you're dealing with arrears that arose after March 19th, and so they're covered by this order, you can still sue for the arrears. So you can't re-enter, you can't take back the premises, you can't distrain, you can't seize the property of the tenant. You could still potentially sue for arrears. Of course, with the courts plugged up right now the way they are, that's not going to move very fast. But it may demonstrate a seriousness of intent on your part if there is a significant arrears. You can also still sue guarantors and indemnitors under the lease. So in many commercial leases, there will be a company, which is the tenant, which has signed a lease, but then there will be, the principal of the company, one of the shareholders, that signs as a guarantor, or sometimes referred to as an indemnitor. So there's nothing here to restrict you from taking action against the indemnitors as well. So I just wanted to unpack that a little bit. I mean, there's a lot more that could be talked about, but I think sometimes when people see this order, they kind of feel like there's a blanket prohibition on taking action, and I think it's a little more nuanced than that. So at that, I will bring my presentation to an end. If anybody wants to take a picture of that, go ahead. Disclaimers, and there we go. So over to you, Lindsay. Certainly happy to take any questions anyone may have at the end of the presentation. And I will stop sharing now.
I was going to say, you got to.
There we go. Yeah.
Give me the screen here. All right. Where's my slideshow? Oh, shoot. Hold on, everyone. That's interesting. Now let's just go back. All right. Good morning. Thank you all for being here this morning. As Mike earlier said, we're going to split it. He's covered some of the contractual legal implications of COVID-19, and now I'm going to walk you through some of the employment law perspective. I practice at the firm of Connors Stillwell. We are also primarily a corporate commercial law firm, but we also offer employment law. And most of the employment law we do is from the perspective of the employer. We also, I'm not going to be touching on labor considerations. So if you work in a workplace that is governed by a collective agreement, union implications, we're not going to get into that today. That's something you should speak to your legal counsel about, because there will be other considerations if you're operating in that environment. All right, I'm just going to cover off a few some of your obligations, talk a bit about what happens when employees are infected with COVID-19 or expect that they will be because of contact with another COVID-19 person with COVID-19. We're going to talk a bit about temporary layoffs and the difference between that and terminations and what your obligations are. And I'm briefly going to touch on some of the support programs simply because they are a way of mitigating some of your business losses related to employees. But as we all know, they are changing quite rapidly within the federal government. It seems almost, for while they're daily and now weekly, we are getting new information. So we'll briefly touch on those, but I encourage you to follow canada.ca, the website, for up-to-date information on them. All right, so you as an employer have certain obligations to your employees, and one of them is to provide a safe work environment. There are some ways in which you can ensure that. One is the sharing of information with your employees. So you have an obligation to stay current on what as the laws related to COVID-19 change. So for instance, the state of emergency, any sort of guidelines from WorkSafe and public health. And so you have probably already by now, given that the state of emergency was declared on March 19th, you probably by now understand what your operations can look like according to those. But you must follow those guidelines, and they are very explicit as to what operating looks like. For instance, the requirement to stay to ensure that those in the workplace, if you're allowed to be open, have to stay 2 meters apart. Those that need to become within 2 meters, that has to be minimal, that interaction. There is also the importance of workplace sanitation. So you'll want to consider having hygienic products available, such as hand sanitizer if you can access it. It's not easy to right now, but at minimum, posting about hand washing and ensuring that employees have access to hand washing stations, as well as increasing the cleaning that's done in the workplace, regularly wiping down surfaces that in the workplace that employees are encountering and touching, and that can be points of contamination. You as an employer have an obligation to keep those clean. The social distancing measures, as we talked about, those changed rapidly with the state of emergency as to what your obligations are. Most workplaces are not allowed to have any sort of public facing at this point, or very minimal public facing, public interaction. You have an obligation to ensure that your employees can work a certain distance apart, except for minimal opportunity to come in contact with each other. There needs to be restrictions on who can attend your place of work. So visitors, for instance, would be prohibited at this point. Clients that may be coming in, you need to take precautions to ensure they are not exhibiting or feeling any symptoms of COVID-19. You're also going to want to take a look at your sick leave policies and your leave of absence policies in light of this. What we want employers to do is to not set up any deterrents for employees that need to stay home because they're sick. The federal government and the provincial government have unrolled support measures that will allow them to financially, but if there are reasons why, if an employee's sick leave policy is so stringent at work that they would hide symptoms or come to work despite not feeling well, that is not what we want happening right now. So it's important to take a look at those policies and make sure that you're not in any way deterring an employee from staying home if they're unwell. Now, one question that we have been getting is what happens with, can an employee refuse to work? So an employee can refuse to work in a situation where there is credible danger or risk to their health, but it does need to be credible. It does need, WorkSafe New Brunswick has further information on what an employee would need to do if they wish to file a refusal to work. It's a formal process and they would need to go through that. But if you're having an employee come to you who is refusing to work because they feel unsafe or they believe there's a risk, you do have some obligations to consider whether there are mechanisms which you could implement that would make the situation safer for them. So we see examples throughout Fredericton right now. We see employers have implemented things like plexiglass, cashiers, or allowing and encouraging employees to work from home if that's possible, or taking staff down to a skeleton staff that can be at an office, but there's so few that you can facilitate the social distancing. Posting in your place of work social distancing reminders, signage, those sorts of mechanisms can help ensure the safety of your employees. But at the end of the day, if they do refuse to work, it is a formal process. They do need to consult with WorkSafe MB and file that. And WorkSafe will be in touch with you as an employer. You have a legal obligation right now to adhere to the state of emergency. So there is some guidelines on there as to what you need to be doing. And if you are not adhering to those, there can be fines issued against employers and workplaces in New Brunswick. Travel restrictions. This is probably a bit of a moot point today, but I understand that some some flights are opening back up, including international flights. And as borders open and as work resumes, it's something you as an employer you will need to consider. Certainly right now, all non-essential travel is discouraged or prohibited. As borders open up and the flow of work starts again, you may want to evaluate what is actual essential travel. Certainly if you could refuse to travel if they felt that their risk of contracting COVID-19 was likely or possible even. So reviewing that. With regards to personal travel, that is certainly trickier, prohibiting an employee from traveling on a vacation or something to that effect, but you'll want to bring to their attention any guidelines from Government of Canada, travel advisories, for instance. And also you may want to implement a policy similar to what many employers did before the state of emergency, which was if you have traveled internationally or traveled outside of New Brunswick, depending on what the circumstances are, that you have an obligation to self-isolate at home for 14 days. Some of that may come directly from the government. Some of that may, as we phase through this process, you may wish to have that policy in your workplace to protect the safety of your clients, customers, and other staff. Working from home. We just, of course, we have been encouraged as employers to facilitate employees working from home, those that can. And you may have questions about that. Some of that is about managing those employees, which I won't touch on, but there are some legal implications just for your consideration. You'll want to give consideration to who could work from home and who should work from home in your workplace. Maybe not, this is not an appropriate policy for everyone, depending on the nature of your work or their particular position. You'll want to make it clear, to the best of our ability right now, how long this duration of working from home will last. And that's very difficult right now, but you would want to give some indication to your employees that this is temporary. This is a measure we're implementing at this time because of COVID-19. You'll want to set clear expectations as to what your employee, what you expect your employees to contribute while home. That's more of a management thing, but it helps ensure the employer's comfort, but also the employees' understanding of what's expected from them when they're at home. And information security. I won't pretend to be an IT expert, but you'll definitely want to consult with your IT support with regards to whether there are measures you should be implementing to protect your data and your confidential information and your clients' confidential information when employees are logging in from their homes or remotely. All right. What happens? How, if you are operational, if you are a business, an essential service, or one of the businesses that the government of New Brunswick has designated as allowed to open, how can you proceed in this time of uncertainty around COVID-19? So we are getting a lot of questions about screening for COVID-19 in the workplace. You are certainly able to ask your employees whether they are experiencing any of the symptoms of COVID-19. That is something, with regards to what those symptoms are, we just saw yesterday that the province has given more detail as to what possible symptoms of COVID-19 are. There is things like fever, cough, runny nose became a symptom yesterday. Some of these are going to look a lot like seasonal allergies, so it's a difficult thing to gauge, but certainly anyone exhibiting symptoms or experiencing symptoms of COVID-19 should not be allowed into the workplace and should be told to self-isolate for 14 days and contact the 811 number for further guidance. There have been questions as to whether temperature screening is allowed or appropriate. The challenge with temperature screening, while allowed, is that there's no guarantee of accuracy, and temperature is only one possible symptom. It's important that you would give your employees advance notice. They can choose to consent or not to that, and that any information you gather is treated appropriately, because that is private information. You should never ask your employees, even in this time like this, anything beyond what is reasonable. So are they exhibiting symptoms of COVID-19? Reasonable. Beyond that, possibly not. It's also important, if you were going to do temperature screenings, to give some consideration to what employee would be conducting those. Can you provide them personal safety equipment? That's very challenging even for our healthcare professionals right now. So accessing that for your workplace might be challenging. What happens when an employee tests positive? Well, they need to stay home. They need to stay home, and they will need to be off work until their health professional okays their return to work. If they have an unconfirmed case of COVID-19, if they are one of the ones that have symptoms but they have not been tested, they too must stay home. 14 days after they stop exhibiting symptoms is how long they'll need to stay home for, and they should get further guidance on that from a healthcare professional. If an employee tells you they have been exposed or they think they've been exposed, they may live with someone with COVID-19 or they work with someone with COVID-19, they too should self-isolate for 14 days once that contact has been confirmed. and people they have. You will also need to give consideration to who they've been in contact with in the workplace. And those fellow employees that work directly around them, they too should be self-isolating at home for 14 days. You do not, as an employer, have an obligation to report this to the province. But you may wish to contact public health to get assistance with contact tracing. So, or further guidance as to how many other employees in the workplace should be self-isolating now that we've had this occurrence. Stay mindful of, despite this global pandemic, there are still human rights and privacy considerations that you as an employer should be making. And so while some of this idea of a lot of human rights concerns that have not been tested because we've not seen a global pandemic of this scale before, you should be mindful that you cannot discriminate out of fear that someone may be a source of transmission for this. Likewise, if someone is staying home because of childcare, they need to provide care for their family or children. Be careful, there are grounds of discrimination. When you're sending someone home, focus on the fact that they are sick or exhibiting symptoms, and not out of a fear that they may transmit the virus. Be careful not to reinforce any stereotypes. There have been unfortunate and inappropriate stereotyping of who might be carrying or transmitting COVID-19, and discrimination because of that, and that would open you up to human rights challenges. Leaves of absence. Under the Employment Standards Act of New Brunswick and under the Canada Labour Code, employees are granted leaves, unpaid but protected leaves of absence. So, for instance, under the federal Canadian Labour Code, if you're a federally regulated workplace, and you probably know if you are, but if in doubt, we can confirm that for you. Employees have 16 weeks of unpaid but job protected leave, which means if related to COVID. So they can be home, whether it be for childcare, whether they are sick, whether they are caring for someone who's sick, for 16 weeks. You have no obligation to pay them, but their job is protected. In New Brunswick, there's a range of leaves. So there is some sick leave time, family care, and those are, again, you have no obligation to pay your employees during those leaves, but they do have a legal entitlement to take that time. All right. If you are in a position, or you have already been in a position where, due to the measures put in place to halt the spread of COVID-19, you are facing the reality that you will need to lay off or terminate some of your employees, I want to go through some of these provisions. Now, if your employees have an employment contract, or as I mentioned earlier, collective bargaining, there may be other provisions that layer onto these that you'll need to be mindful of, and you'll want to have those contracts and collective agreements reviewed by your own legal counsel. But there are legislative provisions that do govern this. So, for instance, the New Brunswick Employment Standards Act is what, provided you are not a federally regulated employer, you are governed by the New Brunswick Employment Standards Act. It has provided clarification that you may temporarily lay off an employee without notice, which means you're not obligated to give any advance notice of the layoff or any pay in lieu of notice if there is a lack of work due to any reason unforeseen by the employer. And the New Brunswick government has confirmed that COVID-19 is an unforeseen reason. However, that is what the legislation says here in New Brunswick. I should mention that the Federal Labor Code also, you are not required, provided that the layoff is for no more than 3 months, you are not obligated to provide any notice. That's what the legislation says. Common law says something different, and we'll get to that further down the slide. A termination is different than a temporary layoff. A temporary layoff is you're going to be shut for a month, 3 months, but you fully intend to bring the employee back. A termination is different. You are closing, you are terminating this employee's position. There are still, nothing has changed with regards to your notice obligations under COVID-19 if you are terminating their employment. If they will not work for you again, then you need to provide them the appropriate notice. And the legislative requirement in New Brunswick is 2 weeks if they've worked for you for less than 5 years, and 4 weeks if they've worked for you more than 5 years or more. There are separate notice periods under the Canada Labour Code that range depending on how long they've worked for you. That's just what the legislation says. Of course, common law would allow for greater notice or pay in lieu of notice, depending on the length of time the employee has worked for you, the age of the employee, the nature of the position. Their employment contract also may provide provisions for what their notice entitlement is, and it's important to review all those. So if the employee will not be returning to work, and you know that, that's a termination, and nothing about COVID-19 changes your obligations to them. But if this is a temporary layoff, if you are closing or laying off employees for the time being due to lack of work because of COVID-19, you do not need to provide notice, but you do need to be aware that this layoff could be construed as a constructive dismissal. A constructive dismissal is where there's a fundamental change to the employee's terms of work. So laying them off without pay could be construed as constructive dismissal. Nonetheless, most employers that are doing this have very few options right now. And while untested, we anticipate that the one position the courts could take was that it was reasonable. The employers made a reasonable decision based on the declaration of state of emergency, based on what the rules around operations were, that this was reasonable, but untested. There are some ways you can mitigate the likelihood that a employee alleges constructive dismissal, and that's things like staying in contact with your employees during this period of time, ensuring in the notice that when you do lay them off, you do have an obligation to put that notice in writing and provide them with a record of employment to facilitate their application for benefits. Stay in touch with them, ensure they know that this is temporary. You may not be able to provide a return to work date yet, but that they know that that's the intent that you do. If you have benefit plans that they can remain part of, so health benefits, you'll want to check with your benefit provider to see if your contract allows for that. And that could be that would be a mitigation to the employee claiming constructive dismissal. If you are going to be offering any top-ups for benefits, you'll want to review the federal government's guidelines for when to register the supplementary plans. They need to be registered at Service Canada to ensure that they're not subject to employment insurance deductions. All right. This is the section that, thanks to the Chamber of Commerce, regular daily emails, we have been able to stay abreast of many of these changes in these programs as they're announced. But here's the lay of the land. Again, I'm not going to go into them with great detail because time, and the Chamber of Commerce has been doing an excellent job of providing you information on these. But here are some support programs that may help you avoid layoffs or terminations. So the Canada Emergency Wage Subsidy, that's the 75% of the employee's wage up to approximately $58,000. That eligibility criteria changed on Friday, so you'll want to review that, including the fact that now March, they're only looking at 2 weeks of what your loss of in revenue was in March. You'll want to talk with your accountant to help calculate your eligibility for that and review the most recent guidelines. But even if you don't qualify or are eligible for the Canada Emergency Wage Subsidy, the temporary 10% wage subsidy may be something that you are in fact eligible for still. The Work Share program is an interesting program under Service Canada that allows for you to reduce the hours of work, and so perhaps you go down to your employees move to a part-time. Federal government will top up their wages during that. And the Canada Summer Jobs Program, for those of you hiring students this summer, they've actually announced that they'll be covering $100,000, 100% of those wages. Employees may ask when you deliver the layoff notice, they may have questions for you about their benefits. You'll want to direct them to Service Canada to learn more about what we're calling CERB, Canada Emergency Response Benefit, which gives them $2,000 a month, or employment insurance. And there is the federal government continues to provide clarity on how those work together. And then for those of you on the call that may be self-employed, there are some benefits that do apply to you, the CERB, and an ability to defer your payment of taxes and some of the payments under the excise and duty and customs and duty. So you'll want to review those options as possible ways that you can mitigate your losses. Okay, that was a very quick and high level. As always, I'm happy to answer some questions, and perhaps we can, if it's going to be a lengthy answer, we might want to go offline, and I can provide you some further clarity on any of those issues. And thank you.
Thanks so much to both Mike and Lindsay for these presentations. They were excellent. I see that there's a question for both of you in our chat. Lindsay, you've just finished talking about CERB, so I'm going to throw that question at you first. A few of our members have asked about, and it's from me, that's why it's going first. Being as I was able to unmute myself. A few members have asked about situations where their employees have indicated they prefer not to work, as the CERB plus the Provincial Emergency Fund, along with increased HST or GST refund and child tax credit, make it appealing to be off work. Does the employer have the right to require their employees to work if they are able to provide an opportunity for them to work?
Yes, provided that you are able to be operational and you're not in contravention of the state of emergency, and provided you can provide a safe workspace, yes, your employees must come to work or quit. And if they quit their employment, they are not eligible for CERB, is my understanding. Now, I say that with the condition that some of what we're seeing, remember, if they have childcare obligations or they are caring for a loved one who's sick, not accommodating, you're going to need to consider your human rights obligations to accommodate that request because of some of the grounds, family status grounds. So that may be tricky, but provided it's just an employee who is saying, I just don't want to work because these benefits, I would be making as much or close if I was collecting these benefits, and therefore I don't want to report to work, and there's no further need that could require accommodation. Yeah, they don't have the right to just stay home.
Yeah, I have one employer who actually did all the math and said that the employee would be working for about $100 a week and didn't want to come to work.
It's interesting. This isn't, some of that I understand, hearing the same media that a lot of you are, is that the federal government is looking at some of those programs that around some of the service sector employees that are working, service sector, home care workers. They're essential workers. They're what are keeping this possible, but unfortunately their salaries and wages are typically very close to that line, that $100 more than what they would collect with benefits at home. And I understand the federal government's looking at that and thinking about ways they could, I don't know what that will look like, but from a strictly legal perspective, they don't have the right to stay home unless it's on health and safety grounds or caregiver or one of those other protected grounds.
One way that I think some employers may have gotten themselves into difficulty, I have a couple of clients that run into this, is that in the very early days of the, the declarations of emergency and those various steps, employers, some were trying to be very proactive, right? And trying to quell the worries of the employees, and some of them may have sort of inadvertently brought in policies that were maybe a little over generous. I mean, do you think there's an easy fix to that? I mean, I guess you just have to walk it back.
Yeah, I mean, it depends how ingrained the policy was.
Yeah.
Did they change the employment contract, or was it just
Yeah, I mean, these are people without written employment
Yeah.
agreements. I think it's more, it's more kind of, word of mouth practice type stuff, but
yeah.
Mike, there's a question there, I think, that is directed towards your presentation as well.
Sure.
If I heard correctly, waivers in writing could be a useful tool at this time to mitigate risks. However, can a waiver protect a person if they're on the line or cross the line of COVID-19 health guidelines, such as entering a building at your own risk? Am I hearing correctly? A waiver can mitigate exposure or possible lawsuit if someone is going into a building who signs a waiver that they knew the risk but wants to buy a property, wanting to go in the building but ends up getting the virus. That is from Jamie Ryan. Jamie is the executive director of the New Brunswick Real Estate Association, which would explain that question.
Yeah. So, yeah, I mean, the context in which I brought up waivers in my presentation was really more in terms of waiving, express contractual obligations, right? So, waiving obligations to make certain payments on time or deliver services or products, on time or to a certain level, that sort of thing. I mean, in a broader sense, I mean, it certainly can't hurt you. I mean, I don't know if I can say definitively that, a waiver is going to protect you if you bring someone into, an inherently dangerous situation, right? And I don't know, frankly, I mean, with some of the restrictions, I mean, even for services that are permitted to continue right now, they are still subject to, the personal distancing guidelines and the other kind of safety measures that are in place. So I don't think, for example, I think you'd have an uphill battle if you sort of brought someone into a situation where you weren't observing those safety protocols or a situation that was inherently unsafe. I don't think the fact that you got someone to sign a form, or scribble a signature standing up against the door at the last minute is necessarily going to protect you. I mean, I think putting warnings, notices, maybe having people sign an acknowledgement, that might be helpful to an extent. But I think really what it's going to come down to is, observing the best practices and making sure that what you're doing is in compliance with the mandatory order. That would be my thought. But I'd be curious, I mean, Lindsay may have some thoughts on this as well. I mean, it's kind of there's a bit of an occupational health and safety flavor to it as well, potentially.
Yeah, I mean, a lot of that, in a real estate perspective, it's my understanding a lot of the realtors are independent, like self-employed folks, so they wouldn't necessarily, depends on who's entering the premises, to Mike's point, and using your best judgment in terms of how you can ensure a safe work environment for any employees. And that's tricky when you're entering a home or asking an assistant to enter a home that you don't know, you have not been privy to, has been cleaned appropriately, or who was last in the home. So that's a difficult situation to mitigate.
I mean, I think it certainly wouldn't hurt, to have someone sign something, but whether or not that's going to be a silver bullet, I kind of have my doubts. I think it's going to be your practices and the measures you put in place to protect people that are going to be more important in all likelihood.
I'm going to jump in with a third, and what I think from our time perspective, our last question. I know we had booked this until 11 o'clock. So if people have to jump off, we thank you for participating. We hope that you receive some benefit from this and learn some things that you didn't know before. And I will hop on our last question, and then I will give a little PSA for another event we have coming up. So the final question is from Beth Crowell. Our lease is up. We're being asked to sign another 5-year lease. Of course, we're up in the air about signing it at this time. Would I be personally responsible for the payment of the lease should our company remain closed for an extended amount of time?
So that really is a matter of contract. That just depends on whether or not you're a guarantor under the lease or whether you sign the lease in your personal capacity. So, most business people will incorporate a company to, sign the lease and, own the assets and enter into contracts with, customers and suppliers and such. And the idea there is that the corporation is, legally has all the capacities of a natural person, and it's the one that would be subject to, a lawsuit, for example. But of course, many times in commercial leases, the landlord will want the individual behind the company to also sign on either as a guarantor or an indemnitor. And if you do sign on as a guarantor or an indemnitor and agree to be personally liable, then yes, I would say if you sign a 5-year lease, and if, for whatever reason, it becomes, unfeasible, then yes, you would be subject to personal liability. So definitely something to consider and try and negotiate. I mean, maybe the landlord's on the line too. I don't know. I don't want to double speak here too much, but I mean, if you can get some kind of a shorter term extension, sometimes leases have overholding clauses, which essentially convert it into a month-to-month tenancy after the initial term if there's no formal renewal. There may be a couple of kind of interim steps. Maybe you can do a shorter renewal or put in some other kind of protection. I mean, obviously, if you could get the landlord to accept a force majeure clause that did not exclude payment of rent as one of the contractual obligations that's covered, then you'd probably be golden. But very few landlords accept that. So I mean, there are a couple of ways you can try to massage it, but the bottom line is, if you sign on as a guarantor or indemnitor in your personal capacity, then yes, they will have recourse to you personally if the company doesn't pay the rent.
So thank you for that. And I hope that has answered people's questions. I want to tell you that tomorrow we are hosting a conversation with the Honorable Melanie Joly. She is the Federal Minister of Economic Development, also responsible for ACOA. It's at 10:30. The maximum attendees we can have on this call is 100. And we're heading towards that number now. We just announced this on Thursday, I guess. So it is filling up, but what we will be doing is she will be making a presentation and then she will be answering questions. Now, we would appreciate if you do have a question for Minister Joly, whether you can participate in the call or not, send us those questions and we will be posing them to her. We are also recording this session and we will be posting the recorded session afterwards. So if you have questions that you feel that her department should or could answer for you and for your business and for your industry, we'd really appreciate receiving them from you. We will be providing the questions in advance, because the idea, of course, isn't to surprise her with difficult questions, but to get really good information from the Department of Economic Development and from ACOA that will help our members navigate this situation. So we are looking forward to that tomorrow. So today we do want to say thank you so much to both Lindsay and to Mike and to their firms, Connor Stillwell and McInnes Cooper, for providing us this excellent webinar. We really appreciate it. I see some people are putting applause hands on their posts, so that's awesome. And I don't think we had anybody sign off, even though we went 5 minutes over. So we very much appreciate, oh, there's some more clapping hands from Jermaine, thank you. So we very much appreciate your insight today and the information that you were able to share with us and our members, and look forward to doing sessions like this hopefully again in the future. So thanks very much, and thanks everybody for signing on today. Really appreciate it. Thank you, and goodbye.
That's great. Thank you. Our pleasure.
Thank you.